The officer hands back your license, hands back your registration. The stop is basically over. You feel your shoulders drop. Then he leans against your door, softens his voice, and says, "So where are you coming from tonight?" It sounds like small talk. It is not small talk. That question is the most commonly used legal hook in traffic stop history. And the moment you answer it, honestly, innocently, without hesitation, you may have just handed law enforcement the geographic evidence they need to extend that stop, justify a search, and build a case against you. Not because you did anything wrong, because you answered a question you had no legal obligation to answer. Your location can place you near a crime scene. Your timeline can contradict what a witness said. Your destination can connect you to someone under investigation. None of that is obvious when the officer is leaning on your door smiling. All of it is on body cam the moment the words leave your mouth. And body cam footage does not care what you intended when you answered. It only captures what you said. Prosecutors watch that footage looking for exactly this. The moment after the license comes back, when the driver's guard drops and the words start flowing freely. That moment is what this video is about. This is educational content to help you understand your rights. For specific legal guidance, consult a licensed attorney in your jurisdiction. I have analyzed over 200 body cam recordings of this exact moment, the post-handback question, and studied every controlling Supreme Court case on roadside questioning, detention, and the Fifth Amendment. I have identified 4 exact phrases that protect you the moment that question lands. Most drivers have never heard them. After today, you will. Subscribe right now. In a few days, I am dropping the video on what to do when an officer says they smell something in your car. That is the #1 way a routine stop becomes an arrest. If you are not subscribed, you will not see it when you need it most. Stay calm, stay polite, but understand what that question is actually asking. Here are the 4 phrases every driver needs the moment an officer asks where you are coming from. Phrase number 1. Officer, am I being detained or am I free to go? Here is the mistake nearly every driver makes. The license comes back, the warning is handed over. The officer asks one more casual question, and the driver answers it. Because the stop feels like it is winding down, because the mood has shifted, because saying nothing now feels rude or suspicious after a smooth interaction. Picture the moment. Your documents are back in your hand. The officer has not moved. He looks relaxed. So where are you coming from tonight? Just curious. You think, it is almost over. I may as well just answer. And you do. Here is what the law actually says. In Rodriguez versus United States, decided unanimously by the Supreme Court in 2015, the court ruled that a traffic stop cannot extend beyond the time necessary to complete its original purpose without independent, reasonable suspicion of a crime. The moment your documents are returned and the ticket or warning is issued, the legal authority that justified that stop reaches its limit. But in Ohio versus Robinette, the court held that officers are not required to inform you that you are free to go before asking for consent or asking additional questions. That means the officer can keep standing there, keep asking, keep the encounter alive, and nothing in the law requires him to tell you it is optional. You have to ask. You have to force the moment into the open yourself. Officer, am I being detained or am I free to go? Again. Officer, am I being detained or am I free to go? One more time. Officer, am I being detained or am I free to go? Flat tone, respectful. Not a challenge, a legal question. That question forces the officer to choose on body cam. Either you are free to go, in which case you leave calmly, no further words, or you are being detained, in which case the officer must have independent, reasonable suspicion directed at you personally, and whatever he says to justify that detention is now on the permanent record. The bottom line. Do not wait for the officer to tell you the stop is over. Under the law, he does not have to. You have to ask. Phrase number 2. I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. Here is the mistake. The officer says you are not free to go, and you go quiet. You sit there saying nothing, assuming silence is protection. It is not. In Salinas versus Texas, decided by the Supreme Court in 2013 in a 5-4 ruling, the court held that the Fifth Amendment is not self-executing. Genovevo Salinas stayed silent during police questioning before his arrest. Prosecutors were later permitted to use that silence as evidence of guilt at his murder trial, because Salinas never explicitly invoked the privilege. The court held that simply going quiet is not enough. The words have to be spoken out loud. Silence on its own is legally invisible. What you say on body cam is what the law recognizes. The moment the officer tells you that you are being detained, you say this: I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. Again, I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. One more time. I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. Calm, clear, not angry, not defiant. A legal statement spoken on body cam, creating a record that any continued questioning from this point forward is constitutionally problematic. Any statement obtained after an explicit invocation carries far less legal weight in any proceeding that follows. The bottom line: silence without the words is not a Fifth Amendment invocation. The words make it legally real. Phrase number 3. I have already invoked my right to remain silent. Here is the mistake. You have invoked. The officer nods. Then 30 seconds later he tries a different angle. He softens his voice again. Just help me understand. Where were you earlier tonight? Not a formal interrogation, just a friendly follow-up. And the driver, feeling the pressure ease, starts to answer. Here is what the law actually says. In Berkemer versus McCarty, decided unanimously by the Supreme Court in 1984, the court held that roadside questioning during a traffic stop constitutes custodial interrogation for Fifth Amendment purposes, and that statements made voluntarily during that encounter are admissible. Voluntarily is the operative word. The moment you answer a follow-up question after invoking, the court may treat that answer as voluntary re-engagement. Your invocation does not expire, but your behavior after invoking can undermine it. Every follow-up question after your invocation requires the same response. You say this: I have already invoked my right to remain silent. Again, I have already invoked my right to remain silent. One more time. I have already invoked my right to remain silent. Nothing else. No explanation. No frustration in your voice. The phrase is a wall. Every time the question changes, the wall stays the same. An officer who continues questioning after a clear and repeated invocation is building a suppression problem for any prosecutor who picks up the case. The bottom line: your invocation does not wear out, but you have to hold it every single time a new question arrives. Phrase number 4. On what specific and articulable facts am I being detained? Here is the mistake. The officer says you are being detained. Most drivers accept that. They sit, they wait. They let the encounter drift wherever the officer takes it, assuming that detained means they have no more options. Here is what the law actually says. In Terry versus Ohio, the Supreme Court established that a detention must be based on specific, articulable facts of criminal activity directed at the person being detained. Not a hunch, not a feeling, not general suspicion. In Brown versus Texas, decided unanimously in 1979, the court ruled that demanding identification or detaining a person without individualized reasonable suspicion violates the Fourth Amendment. Being stopped in a car that was pulled over is not, by itself, a basis for your continued personal detention once the traffic purpose is complete. So when the officer tells you that you are being detained, you say this: on what specific and articulable facts am I being detained? Again, on what specific and articulable facts am I being detained? One more time. On what specific and articulable facts am I being detained? Calm. No edge in the voice. A constitutional question, not a confrontation. Whatever the officer says next is now on body cam. If he articulates specific facts tied to your conduct, something you did, something observed directly, that response becomes the legal foundation of the detention. If he cannot articulate specific facts and falls back on generalized claims, that answer is the foundation of a future suppression motion. Either way, you have forced the legal basis of your detention onto the record. If the officer provides a lawful basis and orders you to stay, you stay. But you say this first: I am remaining here under protest. I am not consenting to any searches or any extension of this stop beyond what the law requires. The bottom line: a detention without articulable facts is a Fourth Amendment violation. Asking for those facts on camera is a constitutional right, not obstruction. Here is what it looks like in a single stop. Documents come back, officer leans in. So where are you coming from tonight? You say, Officer, am I being detained or am I free to go? He says you are not free to go. You say, I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. He tries a softer angle 30 seconds later. You say, I have already invoked my right to remain silent. He says he is detaining you. You say, On what specific and articulable facts am I being detained? He answers, whatever he says is on body cam. If it is lawful, you remain. If it is not, your attorney has something real to work with. 4 phrases. The stop either ends or it goes on the record. This is educational content only and not legal advice. Laws vary by state. Always consult a qualified attorney in your jurisdiction for your specific situation. In a few days, I am dropping the video on what to do when an officer says they smell something in your car. One of the most abused claims in traffic stop history, and it ends in an arrest every single day in situations where the driver had every right to drive away clean. Subscribe right now so you do not miss it. Smash the like button if this changed how you will answer that question from now on. And drop a comment right now. Have you ever answered "Where are you coming from?" without thinking twice about it? I read every comment. Stay sharp. Know your rights.